Hello and welcome to the Business Advocate Podcast. My name is Russell Carrier. I'm the owner of First Choice Business Brokers of East Tennessee and Nashville. And today we have a great topic that we're going to be covering. We have a great guest. He's been on before, John Murphy with Mercury Legal Group. And we're going to be covering certain items within an agreement that when I say we, I mean business owners, kind of gloss over. And so John is going to explain why we shouldn't and, and define these a little bit for us. So John, welcome to the show.
Well, Russell, thanks for having me again. I really appreciate it.
Absolutely. Tell everybody who you work for.
Mercury Legal Group is a business and transactional law firm specializing in providing fractional general counsel for small and medium businesses. And when we talk about fractional general counsel, we're talking about who is that go-to legal counsel for interpreting contracts, negotiating contracts, looking at mitigating the risk across the enterprise. So when we're saying fractional general counsel, it really means that general counsel for your small and medium business, because the obligations for small and medium businesses are basically the same as big businesses, and having that legal counsel in your corner can help mitigate risk.
Very good. Awesome. So we have to do this. Go ahead and give your disclaimer.
Well, thanks for teeing me up on that. Unfortunately, yes, it comes with the legal territory, but this information is provided is intended for general informational purposes only. It's educational. It should definitely not be construed as legal advice or a legal opinion on any specific facts or circumstances. No attorney-client relationship is created by either reading, accessing, or listening to this information. The material is not a substitute for professional legal advice tailored to your individual needs. So consult with a licensed attorney in your jurisdiction for advice on your specific legal issues and circumstances.
And there we go. There. Okay. So we got the legal part done.
Yeah, right. There you go.
All right. So
always important to have the disclaimer.
You got to have it. So we're going to jump right in. And John is actually the one that contacted me in regard to this topic today. And he's going to describe why here in a minute. But this is so important. As business owners, we deal with a lot of agreements. We deal with a lot of contracts. And most of the time we blow right through it. We sign our name, date it, and away it goes. And then an issue arises. And then we read it. And then we find out, well, darn it. We probably shouldn't have signed this. We probably should have sent it to our attorney because, well, we're going to cover three topics. And what are those three topics, John?
So the three clauses that we generally see most often that really confuses our clients and of course parties to potential contracts. Number one is indemnification. To your point, Russell, one that gets glossed over, but it might be one of the more important legal terms in a contract. Two is choice of law, or sometimes called governing law. And then the third is dispute resolutions. Those are the three terms that can sometimes be really complicated and confusing for various parties to a contract.
Absolutely. 100% agree. And I'm really excited to discuss this, especially the first one.
Yes.
Because it's a word that most people, they look up and find you can get this definition off of Google, wherever. But what it truly means and where it's placed and everything that comes after it is so important.
It is so important, and especially when we're looking at the nature of the relationship between the parties and what is the service or goods that are being provided or exchanged between the parties. And to your earlier point, when we were talking about this podcast, I was having a conversation with a friend about indemnification and about how often you see parties completely overlooking this term and not really understanding its mechanics and how it works, not just from a legal perspective, but also from a practical perspective. So, what does this mean for your business and for you personally? And what are your obligations to it? And, there's the boilerplate definition of indemnification, being a contractual term that shifts responsibility or responsibility shifting provision, mitigating the risk. But what does that actually mean? And where I like to start with explaining it to folks is it's kind of like having an insurance policy within a contract. Because the indemnification, if you just exchange that word for, and it's not exactly a one for one exchange. So I'm not saying that it is insurance, but it kind of operates in a way. So indemnification in is essentially providing an insurance. I'm using that in air quotes to cover losses or liabilities suffered to another party because of the nature of the contract. And so, what does that mean? Well, if you have a third party claim for some bad thing that happens, and party A is the indemnitor or the person that says, hey, I'm going to indemnify party B against third party claims, then party B has to show up and defend itself against this third party claim. And then they say, you know what, we weren't responsible for the bad thing that happened, but we still had to show up and defend ourselves in court. So now we have all these legal fees and attorneys fees and travel costs or anything that are associated with the outcome in relation to this contract. We want to go after party A who indemnified us, who gave us this indemnity to reimburse us for our expenses or losses related to that. So when you see indemnification, it's a clause that could have enormous consequences financially for a business if something happens in relation to this contract that creates a financial exposure or financial liability. And when you explain it to someone like that, then they start understanding, okay, this actually is a provision that could have financial implications for my business. No one, of course, we don't want the bad thing to happen. And no one goes into that type of relationship wanting something bad to happen. But it is a provision that's really important for both parties to understand what their rights, responsibilities, and obligations are to the party in the event that there is some type of, whether it's a third party claim or some other event that triggers an indemnity.
Okay. So it's an insurance policy, but you still have to defend it as party B, is what I just heard. So,
Yep. And that's where it gets complicated, right? They can be broad. They can be more tailored, more specific to just certain types of claims or excluding certain types of damages. It just all depends on what is that clause saying. And there have been, I've looked at contracts that have a whole page, a page and a half on how the indemnity works, how you seek one, notice requirements, notifying parties that there is a potential cause of action that's coming from a third party. So the mechanics of it works in various different permutations, but it's really important to identify that clause and the responsibilities that party might have. And in fact, it's the one that parties least understand, but it's the one that it's the one that almost always gets the two attorneys. If both parties being represented, it's almost the one that gets the attorneys, back and forth, redlining. I don't think that our client's going to be willing to agree to this type of indemnity versus that type of indemnity because it's one that could have implications down the road.
So what I'm hearing is be careful
Yes.
when you're reading it that it's not too vague, number one,
Yes.
that you better have an attorney on your side so that you are truly protected and that you're not exposing yourself to that third party as party B to basically go back against party A and try to recover basically the cost to say, I'm actually insured from this, but I have to pay to defend myself to show that I'm insured from this.
I have to show up to court basically to defend myself to say I'm not responsible for the bad thing that happened, and so court, you should excuse me from this litigation. But just by showing up, you've expended money, right? And so then
Correct.
you say, okay, and that's where that kind of responsibility shifting or cost shifting comes into play. Is now I want to be reimbursed for all the attorney fees that I had to spend because I had to show up and defend myself, because in litigation you never know what's going to happen. But you know, if there are multiple parties involved and a good plaintiff's lawyer says, I'm going to pull in as many people in relation to this event as I can, and they're just going to have to show up and explain why they shouldn't be included in this lawsuit. But from a business standpoint, I want to at least have something in there to make sure that if I do have to show up and defend myself in court, whether I'm responsible or not, I want to be reimbursed my reasonable attorney fees that are involved in that. And so it's one of the ways that you can kind of shift and mitigate responsibility. But for, and again, it depends on all of the, what is the basis of this contract? What is the good or services that's being provided? Maybe it's a cap of indemnity that makes more sense. And that's where the exchange happens. And to your point, Russell, having an attorney that understands how to negotiate those terms, again, depending on the size of the contract, yes, it might be a great business opportunity for the business, but you don't want unlimited exposure. And maybe you're negotiating with a much larger company and you're the small and medium business that we often see, like, a window washer, but they're negotiating with this massive commercial property. And the commercial property is saying, we want you, small, medium business owner, to indemnify us. That could potentially bankrupt them, right? So it all depends on, again, the facts and circumstances and what's going on.
Okay. So I'm just going to, we have to sign an agreement for cell phone service, right?
Right.
Get our little phone. Is that something that we need to bring in an attorney to make sure? Well, I'm truly, because what determines how important the agreement is that we're signing?
Yeah,
Right?
it's interesting. I mean, consumer agreements are there's a term in the law called contracts of adhesion, and the and I don't want to go necessarily into the weeds on contract law specifically, but you get a lot of consumer agreements that are called click wrap or shrink clicks that are saying, you have to agree to these terms and conditions to access our good or to purchase our good or our services.
Mhm.
And that's been litigated. They're mostly enforceable. Again, yes, to buy the cell phone, you might have to agree to terms, but obviously one consumer is probably not going to be able to negotiate the terms of the contract with Verizon Wireless.
Okay.
But yeah, that's a great question.
So what about a lease agreement?
So and that's where, I think for commercial lease agreements and as businesses progress and as they grow from being a small business maybe into a medium business, and then the larger they get and the more contracts that they're negotiating, that is when, it's helpful to have that general counsel there to say, this is what you're being exposed to. This is what the landlord is seeking from you. This is what the risk from a premises liability standpoint looks like. or from a financial exposure, what are you agreeing to provide in terms of repair costs, or what are you agreeing to provide in terms of maybe it's a sublet agreement or a a property use agreement, whatever the case may be. What kind of exposure are you agreeing to? And certainly commercial lease agreements are one that, we generally, when we're working with clients, we say, we want to look at the agreement, redline it, so at least you have a better sense of what you're agreeing to. Because commercial lease agreements, generally are for, longer periods of time. So, what is your financial forecast? What's the outlays? The other term that we see more often that trips folks up is the choice of law.
Okay.
And the choice of law clause is a provision that essentially says what jurisdiction's law is going to be used to interpret and enforce the contract. So you can have a choice of law provision that says, we're going to use New York state law to interpret this contract, to interpret the parties' relationships to each other, the law. So, for example, think about buying a product, and the company's agreement, it says that the choice of law is going to be the terms and conditions are going to be specified using the laws of the state of New York or state of Tennessee or state of Virginia or whichever state, and they insert it into that. Why have this? Because to your point, a lot of business owners kind of gloss over some of the boilerplate clauses without thinking about the practical implications of what this means. For service-based industries that maybe are working with that commercial landlord to provide a service like commercial cleaning or commercial repair, both those parties are in Tennessee most often than not. But maybe that service entity in their service agreement says that they're going to use Delaware law to interpret the relationships of the parties. And so, what is the primary purpose behind that? The parties might be using that to provide clarity or predictability in the case of a dispute. You see this more often though when there is a manufacturing agreement. So a manufacturer is manufacturing something or fabricating a product in one state that they're going to be shipping to another state, and they want home field advantage, as it were, to say, if this party B out in California has a potential claim against me, I want them to have to use Tennessee law in a California court if they file in California, or if they file in Tennessee, I definitely want Tennessee law to apply. Or they may have, in these choice of law provisions, sometimes you see a combination between the law that's being applied and the forum. So where is this issue going to be litigated? And the choice of law says, the forum, a forum selection clause, sometimes you see those things merged, but the forum is going to be in Tennessee, but we're going to use Delaware law to apply it. Or the forum is going to be in Michigan, but we're going to use New York law to apply. And, the parties might be considering this for, there might be more advantageous, caps on tort liability, or there might be a particular nuance to Michigan's or Delaware's contract laws that the party wants to apply. So the interesting thing about choice of law that I find is that it can be really tricky, and a lot of folks don't realize that that there's a whole course in law school, generally called the conflicts of law, that deals with what law is going to apply in a given dispute. And in contracts, they're trying to fix that, right? They're trying to create that predictability so that it's again more of from a practical standpoint. I want to be sure that I'm going to use this law to interpret. Sometimes now I will say that sometimes courts can just say we're not going to enforce this clause. And that's where the real fun begins. And that's why you know, a lot of law schools have the conflicts of law class, because if a court determines that they're not going to enforce that clause, then the question becomes, well, which law should apply? Which jurisdiction's law should we use to interpret this? And that's where the practical part that I mentioned, that's what's going to increase litigation fees. So
Correct.
you've got to say, okay, court, this is the reason why we think New York law should apply. The counterparty might say, no, court, this is the reason why Tennessee law should apply. And then you've got to litigate just what law should apply. And that could take, you know, who knows how long it could take in particularly complex cases. So the legal fees are racking up. And
Yep.
so to create more predictability, that's usually the reason why we see that clause. And that's one where, you know, again, a lot of folks just kind of look over, and if they don't have you know, their general counsel trying to negotiate, you know, yeah, we'll agree to the forum, but we're not going to agree to this choice of law, or maybe we'll agree to the choice of law, but we're not going to agree to this forum, because now if I want to have to, you know, if I do have a valid claim, I've got to file this in that court, and that might be not advantageous.
Absolutely. And I've run into this actually quite a bit with a small business where we're working with larger organizations. And I read agreements. I'm a nerd. And so I go through it and I see that choice of law, right?
Yeah.
And they may be located in the state, city, town where I'm doing business, but their legal team is located someplace else. And
Right.
that's where I find most of the time where that local jurisdiction is applied, because they don't want their attorneys flying all over the country, going to court, filing briefs, sending in briefs in
Yep.
another state. They want it locally to them to reduce their costs.
Yep. Yeah. No,
So,
exactly.
so as a business owner, when you get to that, pay attention to it. Again, hopefully you have an attorney on your side, but at least we're providing the knowledge that these three little topics that we're talking about are extremely important,
Yep.
and read them. Okay.
Yep.
So if you're going through an agreement, you're going to be providing service, you're going to be selling your widgets, whatever you're going to be doing with this other party, and you're signing this agreement, look at them, find out where the choice of venue is going to be. Change it, ask them to change it. I, again, highly recommend speak with an attorney, have them review it. Just it's things to spot, right? This is an educational forum. This is what we're here for. These are little gotchas in agreements, right? So keep your eye out for them.
And Russell, I'm so glad that you mentioned, you know, change it, you know, send it back. Yeah, you know, in my experience, you know, the counterparties are expecting that, especially the larger the business, the more likely it is that they're expecting some type of negotiation. They're expecting some type of red line. They're expecting some type of comment. You know, that initial draft, especially, you know, when you're dealing with an entity that might have in-house counsel that all they do all day is draft these agreements, interpret these agreements, and work with counterparties to negotiate terms. You know, they're often expecting some type of change, some type of give and take. So the expectation is already there.
Very good. And just so you know, as business owners, when we're entering in a contract, depending on who you're entering this contract with, more than likely they just downloaded it off the internet. I'm not lying. Or they did one of these form fields where they filled in what they thought was correct for the agreement. So again, they might not even know what's in their own agreement when they have you sign it. So if you
That's
go
fair.
back to them saying, I'm going to redline this, you might get big saucer eyes and their mouth might drop open and say, well, I certainly didn't expect that. Everybody signs it. Well, no, I don't agree that I'm going to
Yeah.
actually have legal counsel in California when I'm in Tennessee.
Yeah.
And they may, yeah, I really didn't realize that was in the contract. So just be aware. That's the lesson here. Be aware. You don't know who you're doing business with, truly. That's what the agreement's for.
Right. Yep.
Yeah, it's to
Yeah.
protect both sides at the end of the day.
That's exactly
So
right.
make sure
Right.
you're protected.
Yeah.
So let's cover the last one.
So yeah, and I know that I'm gonna try and keep it brief. The dispute resolution, we're seeing a lot more specificity around what does this clause look like? How is it interpreted? You might see some agreements might call it alternative dispute resolutions.
Mhm.
Some agreements might say we only want to use arbitration, mandatory arbitration. Some agreements use it in kind of almost like a phased approach. We're going to say, we agree that parties are going to use mandatory mediation first. If we can't reach resolution via mediation, then there's arbitration. Some just say, we're going to our dispute resolution process is we're going to try and negotiate things in good faith, and if good faith doesn't work, we're going to try mediation before going to court. These clauses are becoming, I think, more and more nuanced and more negotiated to really try to expedite the contracting process. Because at the end of the day, as businesses, we want to, you don't want to slow down a business opportunity. Legal counsel is there, to your point, Russell, to help protect the business entity, to help mitigate risk, to identify exposure. But at the end of the day, there's a business decision to be made, and you don't want to miss out on those business opportunities. But that dispute resolution section can be one area where you're working together to try to reach a really both comprehensive approach to how you're going to just handle disputes between the parties in a way that maximizes potential for reasonable resolutions, depending on the context and situations. They can be complicated, especially when a lot of folks might not think to negotiate the terms of an alternative dispute resolution or a dispute resolution section, but also not understanding mediation and arbitration and how arbitration works. And then the pros and cons. Litigation might take, in the court system, dockets are already overburdened. It takes a while for those processes to play out. Arbitration might be a faster resolution, but it could also potentially be more expensive. Depending on what the clause says, how many arbiters are going to be arbitrating? Is it going to be a panel? Is it going to be one? Is it going to be folks that have a specific background in the subject matter of this contract? The more specificity, potentially that increases the cost. So it's weighing the pros and cons. But again, to your point, it's one not to gloss over.
Well, and honestly, same as you pointed out, I'm seeing it more and more in agreements where it's a stage approach. And as a business owner, when I enter an agreement and where I see that mediation is first, then arbitration, and then litigation, I prefer that. Because normally I don't want to say this in a general term, but you already gave us our disclaimer. So mediation usually handles a lot of disagreements because you get an independent third party that's listening to both sides instead of both sides just banging their heads together and claiming they're right. So I like mediation myself. I like having a third party there who listens to both sides and then talks through it, right?
Right.
I like that because they can point out saying, Russ, you're wrong. And I'm not saying you're wrong, but if you looked at what the other party is saying and what their claim is, you might understand that this might not be a good outcome for you if you continue down this path,
Yeah.
right? And mediation is usually inexpensive comparative to everything else down the list.
Yeah.
So I like those clauses. If it says strictly litigation, I kind of step back and ask why at this
Yeah.
point, because as you said, it's becoming more and more common because it saves both parties money at the end of the
Right.
day.
Right.
So again, another area of an agreement to kind of focus on, read it, understand it, so you are better informed, right? That's
Right.
the whole idea about this.
That's exactly right.
So, I mean, we've been talking now for 25 minutes just on 3 small samples of what's in an agreement. And honestly, we could talk for probably another 2 hours. I mean, really breaking down
No,
these
you're
3
right. Yeah.
sections,
Yeah.
it's because they're so important and we gloss over 'em.
Yeah.
So, what's the moral of the story? Read your agreements. I highly suggest you have an attorney on retainer or a fractional attorney that's in your corner when you have a question. Don't just assume you know what it is. That's just my small opinion. Get it clarified so you know what you're signing. Well, I'll let you close this portion out, John. Um, any last words in regard to these? Just, I mean, God, it's so simple, but they're huge topics.
Yeah. No, you're absolutely right. I think you hit the nail on the head. The watchword is really, um, you know, read. Read and understand. And if it seems complex, that usually means that it is. And that's why it's really good to have that lawyer in your corner.
Awesome. So read it, write it, read your agreements. And obviously, as we talked about, if you're signing a cell phone contract, your cable internet, things of that nature, yes, obviously, those are pretty boilerplate. There's not much we can do as consumers. This is more important when you're entering an agreement to provide a service, to sell widgets, or you're doing a partnership, anything of that nature. I'm going to throw in buying a business, obviously. I think
Right.
everybody understands you better have that agreement. So, things that are really, truly important to your business that can impact it, those are the agreements that you really want to focus on. Lease agreements. I mean, anything that's truly important. So, if you're listening to this and you're like, well, I really like to cover this section of an agreement, please let me know. Put it in the comments, or you really didn't cover these 3 topics enough. We'd like more information. Let us know. Put it in the comments. Okay. If you liked this episode, please like it. If you want to be notified when we have new episodes out, hit that notification and that little bell, and you'll be alerted as these episodes roll out. We appreciate you tuning in today. We are doing this for you. Neither one of us are being paid for this. I don't know if you noticed, there is no sponsorship. We're not giving sales pitches. So this is truly for business owners, because we are business owners. Both John and I, we understand that owning a business can be a struggle. So that's why we do this. So this is 100% for you, the listeners. So please let us know what you want to learn about, and we're going to accommodate it. John, if anybody has a question and they want to contact you directly, what's the best way for them to do that?
My email address is John, JOHN, at mercurylegalgroup.com.
Awesome. So I am your host. My name is Russell Carrier. You are listening to the Business Advocate Podcast. We appreciate you tuning in, and we look forward to bringing you another episode soon. So stay tuned. Oh, and by the way, yes, we are on YouTube. If you want to see our ugly mugs, you can look us up on the Business Advocate Podcast. You'll find us. All righty. So thank you very much, everybody. We'll talk to you soon.